Yes.
Adjournment request, if any, from item number 1 to 8.
May I please, my lord, item number 1. Extremely sorry, I could not file this joint.
You could not file?
Yes, because I could not contact the petitioner, my lord. Due to that, I seek some more time.
Did we ask you to file something?
My lord, yes, I was.
What did I say?
A rejoinder, my lord.
Huh?
Rejoinder, my lord.
Rejoinder. If
Yes,
you
ma'am.
don't require any rejoinder, we can hear you. Anyway, you want time.
My lord.
You are Mr. S.K. Deori.
No, R. Devi.
Mr. R. Deori, learned advocate for the petitioner, seek some more time to file the rejoinder affidavit. Let that be done on or before the next date. Re-notify. Then we put it sometimes in May.
My lord.
Give a date in May.
Yes. Item number 2 also.
It's item number 2, your lord, sir.
7.
1 and 2 are together.
Yeah, no.
7 May.
Deeply also.
और नीचे करो अभी तो कर दो सर में
From item number 9 to 18.
yes
I beg to mention item number 16 and 17, your lordship.
adjournment slip has been circulated. All right.
26 May.
Deeply obliged.
May I please, your lordship? Also, I beg to mention item number 12, 13 and 18, lordship. We have circulated
12
12, 13
12 13
12 and 13.
both are together. 12 and
Together,
13.
yes.
All right.
and also 18 also, lordship.
18 also.
Yes.
All right.
21st May.
Obliged.
Both the matters.
Right.
From item number 19 to 21.
May it please your lordship, I would like to mention item number 19, your honor, for adjournments. I've already circulated the adjournment slip. Your Honor.
Therefore, we are not asking any question. You have
Your Honor,
circulated
it
the
may be
adjournment
fixed.
slip.
I am for some of the respondents. Repeated adjournments have been taken in this matter.
Anyway, adjournment slip has been circulated. You must have consented, no?
Yes, your honor.
Lordship, since 8 years, the matter has been pending before.
Since 8 years.
8 years, the repetition was
Can't
filed
be.
on.
This appeal is of 2024.
It is a rate appeal filed under.
You should have given your, you should not have given your consent, no? When adjournment slip was being circulated, you could have said that no, let it be mentioned before the court. Now that you have consented, can you turn back? Anyway, you want an early date, we can give an early date.
On the next week of Tuesday, it may be fixed.
Next date, oh?
Tuesday.
Tuesday.
No, that
they have
may
also
not be
consented.
possible.
Because yesterday they have asked that matter can be taken on Tuesday.
क्या बोलता है?
वो फंक्शन दिया है वो लोग बोला था ट्यूसडे के लिए.
Ajay, you had given consent for next Tuesday.
Yes, sir.
Next Tuesday or next Thursday?
Next
Whichever.
Tuesday.
Tuesday or Thursday. Okay.
Next Thursday. Let it remain after a week. Next Thursday ka date.
Thank you, your honor.
Right, next. Thursday.
That's all.
26 March.
May I please, your lordship, I beg to mention item 24 and 25 of today's supplementary list. Your lordship, on the last date, I had requested for 2 weeks' time and I was allotted date of 01, lordship, but today it has come up. Lordship, I have the affidavit is not prepared today.
They have
lordship.
filed an IA made a mention, therefore this matter is this.
Let it be called out first.
Lordship,
Let it be called out.
lordship.
Item number 24 and 25.
Lordship.
Mr. Chaudhary, you are appearing, your name.
23, 23.
No, he's asking for 24 and 20.
24 and 25, lordship.
24 and 20. All right, let it be called out.
Any other request?
Lordship, I pray for listing of a matter which is otherwise a fixed matter, your lordship. I have challenged a rule which precludes me from participating in a process of employment, your lordship. In the
Recruitment
meantime,
process is on.
they have published the advertisement for the recruitment, your lordship. And the form.
Lot Mandals.
Yes, your lordship.
Is that the case?
Yes, that is it.
Have we passed some order in some petition?
Not to my knowledge, your lordship.
No. Are you aware of that matter where we have dealt with the issue?
Lordship,
The training,
the training.
with respect to training, 6 months training and then new recruitment, is that the case that you are
That
referring?
is the case, your lordship. Advertisement has been published on 14th, your lordship.
Find out the number of the writ petitions, and whenever it is listed, we will tag your case also.
Lordship, my case notice was already issued, your lordship.
That's the only, what do you want then?
The advertisement has been recently published, your
So
lordship.
file an application.
I filed, your lordship.
When have
So,
you filed it?
Yesterday, your lordship.
Let that IA be listed.
Next week.
Tomorrow, this week, this
No.
bench is not available. Next week, any day. We would have asked for it only tomorrow, but tomorrow this bench is not available.
Next-
So it'll go to the next week.
25th March, 25. Anyone for 14 and 15?
14 and 15. Nobody appears?
No, man.
Anyway, 14 and 15. In view of the adjournment slip which has been circulated, adjourned. All right, yes.
16 June. Supplementary list for orders item 22.
17.
Wait a minute, huh? Where is that order?
Just come up with it. Marked it.
This PIL number should be
1579 of 2015.
79, 2000.
Is a series plan, consists to 79 of 2015. Along
This
with-
case, now there is some mistake, typographical error. This case has come at the instance of the office. In the third paragraph of the judgment dated 16/3/2026, there is a reference of a PIL number 79 of 2025. In fact, the directions of the court referred to in the aforenoted paragraph has been passed in PIL number 79 of 2015. As such, in the judgment dated 16/3/2026, in paragraph 3, the reference to the PIL be read as PIL number 79 of 2015 instead of 79 of 2025. The judgment stands modified to the extent indicated above.
Item 23.
Item 20.
Me to your lordship. Hello, I am for the respondent in this petition, respondent number 1. The appeal has become infructuous in advances, my lord, and a fresh order of transfer has been passed in supersession of the earlier order, which was the subject matter of this petition.
They have filed an IA lordship.
My lord, we have brought on record that order in the IA at page 33. But then, my lord, I am not pressing this IA, my lord. The purpose of filing the IA was to bring this on record and to get the matter listed fast, my lord.
All right. So what is the main petition number? WA number 409 of 2025. What is the date fixed in that appeal?
The 31st.
31st.
31st of March.
Yes.
Let it come on 31st of March.
No, my lord.
Do you withdraw this? Let it be placed along with the.
Yes. My lord,
Yes.
I have already filed a writ petition challenging the, my lord, the subsequent.
Then you have to withdraw this.
My lord, after only this is, my lord, pending, then that cannot be taken up.
That's right.
That's why, my lord, this may be closed, my lord.
Is the appellant, so it is against, now he's in his favor then.
Whatever, both of them have been removed. Here, Mr. M.K. Chaudhary, learned senior advocate for the applicant, bracket IA number 905 of 2026, seeks permission to withdraw this application in view of a decision having been taken by the department of transferring the appellant.
Both,
To a
both the
different
appellant
place.
and the respondent.
Transferring the appellant and the respondent to a different place. First up. As prayed for, this interlocutory application therefore has become infructuous in view of a writ petition having been filed against such decision of the government. Dismissed as withdrawn.
Then the writ appeal may also be, my lord, closed, my lord.
Because you left
Let
still
it
in-
be,
So let it come on 31st, my lord.
No, unless, my lord, this is, if this is pending, my lord, the honorable single.
that we will do it only unless we call for it, we can't say anything. Mr. Datta will have to withdraw that You are the appellant, no?
No, I am the appellant.
I'm
You is the appellant. So
No,
if,
my lord.
unless he withdraws, what do we say?
No, my
We
lord.
will record the same reason and we'll force him rather,
No, my
we'll
lord,
force him.
since the
We'll
my lord-
persuade him to withdraw, otherwise we'll dismiss the appeal.
No, my lord,
This was the question arranged for both of
Since the, my lord, the order of transfer, which was a subject matter of the appeal, that has been, my lord, subsequently superseded, and a fresh order has been passed, my lord, this has become,
It ought to be passed on 31st, no?
in that given.
He is insisting for the matter to be heard.
The purpose is that, my lord, so that the writ petition
But
cannot
you,
be taken
but
up.
you are the appellant.
I am the, my lord, writ petitioner in the, my lord, the writ petition.
Are you the appellant?
No, my lord, I am the
So
respondent.
therefore, he has to withdraw, no?
My lord, I am not saying that, my lord, you are.
Who followed you? Your writ petition cannot be processed, cannot be argued unless this appeal is disposed of. We understand that. Do you need to repeat that, Mr. Chaudhary? But then we can't coerce him into
No, my
withdrawing.
lord,
Mr. Datta, why can't you withdraw? That day also we will
My lord,
only,
let it come on 31st.
that is the only order that we can pass. So why don't do it now? You also challenge that decision.
No, my lord, your lordship said pass the order.
We have said that look into it as far as possible, try and accommodate. They have not been able to do that. We made our views very clear that in transfer matters, unless it is malified, unless it is actuated by malice or something, we are not interfering. That's not our wish. That's the command of the law.
Yes.
We don't do it.
My lord, let
Correct.
it come on 31st, my lord.
But why do you insist?
No, my lord, the reason is
The
that.
reason is that this writ petition filed by Mr. Chaudhary, he can pursue it.
No, my lord,
You will also be required to file your first. writ
as your
petition.
lordship, as it has fallen from your lordship, my lord, I am pressing the appeal on
Anyway,
the very
the
same
appeal-
ground.
The writ appeal shall be listed on 31st of March as directed earlier.
My lord, my lord, puts me into great difficulty.
Doesn't? You say that we have withdrawn.
Because the order, my lord, which is.
You
the-
challenge it, you have not, you have filed your.
Then your lordship may say, my lord, that the honorable single judge may, my lord, pass as he understands, my lord.
Where is the occasion for us to
No,
deal
that
with
is,
that?
that is a matter of stay of my writ petition, my lord. The pendency of this writ appeal is a matter of stay of
Well,
my writ petition, my lord.
Do one thing.
And
My
Now-
lord, she has, in her application also, she has
No,
stated,
Mr.
she has
Datta,
already
Mr. Datta,
joined
his
the post.
Mr. Datta, his apprehensions are absolutely unfounded, but then I don't know what makes him insist for this. So we do one thing. We have this IA listed along with your appeal on Tuesday
use the.
or on Monday,
Is it, that is 24th.
24th. It'll be preponed.
24th,
strike it off.
my lord, let it be on 20,
Mr. M.K. Chaudhary, learned senior advocate,
that will be on 25th. my lord.
submits that the IA number so-and-so has become infructuous in view of the department having passed a fresh order transferring the applicant / writ petitioner and the appellant. The appeal in question, namely writ appeal number so-and-so, is slated to be listed on 31st of March. However, under the changed circumstances and the writ petitioner / applicant having challenged such decision afresh, we deem it appropriate to direct for listing of the appeal along with the present IA on 24th of March,
It will be 25th, my lord.
25th of March.
My lord, my submission was that, my lord, because.
Your
of this-
submission is nothing, your apprehensions are unfounded. You can always process, you can say that this is
No,
the matter.
your lordship has, my lord, recorded my submission that the IA has become infructuous. My submission is that the writ appeal has become infructuous.
Writ appeal and in fact, even the IA and in fact, even the writ appeal has become infructuous.
Obliged.
It's not going to make any change, Mr. Chaudhary. I think Mr. Datta should have agreed for withdrawing that appeal today. Unnecessarily, you will come again on Tuesday. Anyway, that's your choice.
Obliged.
Please, item 3 to 5 for admission.
Item 5, item 5. Yeah, उसमें order
My lord, on two grounds.
You are appearing for all the respondents in all the matters.
Yes, sir.
All right.
Lordship.
29, we have directed to, don't tell it.
Yes, Mr. Roy.
My lord,
Come to page 3 of our order passed in WA number 338 of 2025. We remember correctly,
Yes, on the first case.
if we remember correctly, and it has to be,
Order.
you have to bear it out. That day we were inclined to dismiss your appeal.
That's right, I understand.
You had only said that there are two other respondents also.
Now, my lord, as I find, my lord, the direct single judge has interfered with the order of minor penalty of recovery, basically on two grounds. One, my lord, there is no definite finding, my lord, but linking the charged officer with the misconduct alleged. And second is because of the provision of regulation 60, which provides that there has to be a
Summary.
summary.
That's the only ground that you had argued.
Second is, my lord, there is a circular, the administrative circular, which says unless there is a allegation of theft which are proved, my lord, the recovery cannot be undertaken. That is the circular the land single judge has referred to. Now, my lord, the first finding of the land single judge that there is no definite finding, my lord, has been arrived at by the land single judge based on the order of the disciplinary authority. The lordship kindly come to page 177
Of which appeal?
of the appeal, my lord, the first one.
58.
That's right. First one, Ranjit Singh.
First or second, we don't know. Appeal number 58.
58, yes, 58. My lord, page 177, the petitioner has, after the order passed by the disciplinary authority, has filed, well, two remedies, one appeal and then the review, which is passed by the CMD, my lord. There is a statutory remedy available to him.
That's right.
Page 177. If your lordship come to page 179, which is the relevant part of the order, there the reviewing authority has discussed everything. My lord, page 179, the second paragraph, may I read it, my lord? Lordship will find it that the authority has found.
This calls for an interference and therefore the learned single judge interfered. Come to paragraph 3 of page 179. We must thank you for having pointed out this.
Yes, it is seen, page 3. It is seen that though there doesn't seem to be culpability, this is shed number 1. Next is, this is shed number 1. The shed number 3. Then observe the shed number 1.
Now, why do we go further when the head of the department, head of the organization, that CMD, in his review jurisdiction, he says that there doesn't seem much culpability on the
Right,
part.
my lord, shed number
Therefore,
3.
why to recover that amount? We will say the sealed cover procedure also you follow. We will remove that part of the observation. You can proceed against them, but so far as recovery is concerned, there has to be definite proof of the fact that this loss, which was unusual, is attributable to him.
No, my lord.
And most of these people, at the time of handover and takeover, there was no proper recording.
No, my lord.
So be it. Can it now be thrust upon the employees?
No, my lord, what he was charged with
is negligence. He is the shared in charge. He is the shared in charge. There is a specific.
Suspend him, if possible, dismiss him, but how do we permit you to recover that amount? How have you quantified?
My lord,
It's very difficult, no? It has to be within the parameters of law. Start a disciplinary proceeding against him. You have, Mr. Roy, you have chosen to shift from 58 to 60, regulation 58 to regulation 60.
Yes, my lord.
And so therefore you have not been able to make out any case.
My lord,
And the third ground, which is a very strong ground, there is nothing perverse in the order of the learned single judge. Why do we interfere?
my
Now,
lord,
otherwise it becomes endless.
We follow, your lordship, kindly have a look at this. There's a circular, you know, we have a, my lord, specific guideline, my lord, which you follow, because if there is a negligence we find,
Willful negligence.
yes, my lord. Because he was shared in charge, he is overall in charge of the share. It has to be, my lord, because otherwise, my lord, it will be very difficult. Maybe if lordship is on quantum, my lord, I can.
No, quantum, once it's found that it is willful negligence, they can't question, the employees can't question the quantum. But what does it say? This only says that to follow the procedure.
Yes, where there is
Equally.
loss, where there is loss. The earlier it one says,
You miss
where
out,
there is
you
theft.
miss out on the most important line in the circular, Mr. Roy. That is not inadvertent. That's the sharpness of a lawyer. But then we read something else. Whereas any loss found due to willful negligence of any FCI official, and when negligence is prima facie established.
Yes, it is established. Prima
How do
facie.
you say so?
But not prima facie because he is the shared interest. That itself indicates the shared interest has a definite duty to look into every transaction.
The Chief Justice of this High Court is overall in charge of the entire building. Some theft takes place. What is, how you attribute it to me?
My lord, that would be too much, my lord, because.
You see, when we decide cases, we put ourselves in the shoes of the person who is facing the might of the state, might of a colossus organization like FCI. Now, not that we are being very indulgent to these negligent employees, but if you want to recover, you must have your definite grounds. Right?
Very well, but your lordship has indicated that the other part.
And let us not take a different view. What we, I mean, unless you have some very strong point today.
And the other part, my lord, the regulation 60, I think, my lord, the single judge has missed sub-regulation 2, which specifically provides this. It doesn't require detailed inquiry, detailed one. That's why, my lord, I'm saying it. This is a summary proceeding.
The proceedings, but it must satisfy the conscience of the court, no? We'll say that you can proceed against them, but recovery part, it has to be
That
established.
your lordship can indicate that.
That's right. We'll say that.
The lord.
Yes, what do you have to say?
Regarding this Ranjit Singh case, just we are discussing.
So you're winning that way, there will be no recovery. But then if they proceed against you departmentally for negligence under different regulation of the FCI, we will not stop them. You deserve to be punished. You cannot be made a store in charge ever.
Your lordship, this.
Prima facie it appears. I mean, you can't 240 quintals would not be lost in the transit or something. And that it was not maintained properly was your business. Now, don't argue beyond a point. We have tested because the FCI is a stronger party. Therefore, we are finding fault with them. So far as this recovery is concerned. But you don't have a right to have a clean chit from us, and that you have not filed an appeal. We are not. We do not approve of that part of the order which says that please remove everything, promote them. That we don't say. Just that for recovery, there has not been total establishment, prima facie establishment of negligence. That will help you otherwise.
My lord,
that recovery will stop.
may I draw your attention to the R1, page number 279.
What do you want? You want yourself, you want a direction in his appeal for you to be promoted to a higher post.
No, your lordship.
We are stopping the recovery. Are you understanding what we are saying? We are stopping the recovery. अब इसके बाद क्या बहस करनी है आपको?
Your Lordship, I just wanted to say there are circumstances, things are there. These were beyond the control of FCI even. I will kindly.
Beyond the
Control of FCI even.
what?
This, how these things
So
have.
end result would be what? What would you pray from the court? मुश्किल है. Anyway, because you are a senior person, मैं आपको तुरंत abruptly आपको रोक नहीं रहा हूँ, but और क्या चाहते हैं आप हमसे? You are holding back the court in passing an
Your
order.
Lordship, what has happened because of these memos, these people were not considered for
Agreed.
promotion.
So these grounds, how many times do I need to tell him? These grounds have weighed with us, and therefore we find that there has not been any prima facie establishment of negligence. Otherwise, how do we support the order? और फिर अब और क्या बहस करना है? आप चाहते हैं कि हमने इसमें कहें कि आपको GM बना दिया जाए? You should be made general manager of
Never, Your
FCI.
Lordship, never.
तो फिर आप बस क्यों करते? Let us. His appeal has been dismissed. Look, he sat down. You're still arguing. मुश्किल है. Later, all the three appeals have been heard together and are being disposed of by this common judgment. The appellant, we have heard Mr. P.K. Roy, learned senior advocate for the FCI, and Mr. G.K. Gupta for the respondents in all the appeals. The appellant FCI has questioned the judgment dated. There are three judgments for three different persons, or one judgment.
No, three judgments.
Similar.
Judgments dated so-and-so by a learned single judge of this court in WPC number so-and-so, whereby the fine slapped on the respondents herein has been interfered with and set aside with a direction that the respondents shall not be penalized so far as their promotional avenues are concerned. The further direction in the judgments impugned is that the appellant FCI must resort to sealed cover procedure with respect to the promotion of the respondents to the higher posts. During audit, huge quantities of rice were found short in storage sheds of FCI, of which the respondents were the in charge. The disciplinary authority found that the respondents were to be blamed for the unusual loss, which was directly attributable to the negligence of the respondents. Hence, all the respondents were separately slapped with a fine, which according to the appellant FCI was proportionate to their guilt. From the records of all the three appeals that initially the FCI wanted to initiate departmental proceeding for major penalties against the respondents for the huge losses which had occurred in the storage depots of which they were in charge. But on the basis of the explanations offered by the respondents, it was decided that they be proceeded against under Regulation 60 of the FCI Staff Regulation 1971 which provides for minor penalties. The respondents had appealed against such decision. The respondents had challenged the aforenoted decision of saddling them with fine proportionate to the guilt before the departmental authorities, which was rejected, and the review was preferred by the respondents before the CMD FCI also could not be sustained. In fact, the review order, as pointed out, the review order, as perused by us, gives somewhat stronger reason for slapping the fines on the respondents by explanation that the loss detected the respective storage depots could not have been mere storage loss. That the explanations offered by the respondents did not actually explain their bona fides so far as their negligence was concerned. All of the impugned judgments reflects that the learned single judge, after having gone through the records of each of the case files, and the circular dated 12/2/2008 issued by the FCI, preventing holding of officers or employees of FCI to be responsible for a storage loss, and there being no material disclosed during the departmental proceedings that the loss was due to any fault on the part of the respondent, set aside the original as well as the appellate order, respondents guilty to the extent of their liabilities. Adverting against the aforenoted judgments, Mr. Royal and senior advocate appearing for the appellant FCI submitted that in fact the records provide res ipsa locuta that it was only the negligence of the storage in charge, of the depot in charge, or otherwise the losses would not be of such magnitude. Matter of common knowledge that during storage there are some losses, but losses of the magnitude reported would not have been possible without the storage, without the depot in charge being negligent in recording the stock, being vigilant against any purloining of the food grains. Mr. Roy, learned senior advocate, has also pointed out advisory issued by the FCI with respect to the rate at which the recovery could be made from the FCI staff. This advisory also confirms that any losses found due to willful negligence of any FCI official recovery proceedings be made, but only as per the procedures laid down on the subject and as per the staff regulations. The recovery of such losses from FCI staff is to be made at economic cost prevalent during the period. However, it was further emphasized in the aforenoted advisory that resort to such recovery would only be permissible when negligence is prima facie established. The contention of the respondents before the learned single judge and before this court has been that because of the losses reported, there is an inferential guilt which the FCI was under an obligation to establish prima facie for them to order for it to order for recovery from its employees. True it is that a summary procedure was adopted where it might not have been extremely necessary to sift through the materials with the aid of a judicial colander. But then, seeking recovery from an employee, facts which are not established would be against the public policy and would also be against the circulars issued from time to time by the FCI and its advisory for the process or the procedure to be evenly followed pan-India. The contention of the respondents is that the learned single judge took note of the fact that such losses were because of wrong reporting in the stock, which was not possible for the respondents to tinker with, especially when they had joined the respective duties at a time when that shortage was pre-existing. True it is that such losses had to be reported, but only if it were evident at the time of joining of the respondents in the respective depots or during their tenure as a storage/shed in charge. This discovery was made much later in the regular audit, for which the respondents could not have been blamed. Thus, finding no fault with we have perused the records, the evidence before the authorities, mindful of the fact that it was a summary proceeding under Regulation 60 of the rules of FCI, are of the considered view that the negligence attributable to the respondents for the losses could not be established for the FCI to initiate the recovery proceedings. Thus, we sustain the judgments impugned in the present set of appeals so far as stoppage of recovery is concerned. Since only a summary procedure was initiated against the respondents, there was no occasion for the employer FCI to determine the guilt of negligence of the respondents. First up, it would be open for the appellants. It would be open for the appellant FCI to initiate requisite proceeding against the respondents individually, should it be deemed necessary for the efficient working of the corporation in general. First up, any observation made by the learned single judge in the impugned judgments regarding no proceeding being initiated against the respondent shall not be given effect to. First up, with the aforenoted modification in the impugned judgments, all the three appeals are dismissed, are disposed of.
Deeply obliged.
Item number 6 and 7.
Unless you're reviewing it.
Wait, Your Lordship.
Yes, sir.
Basically, it's a seniority dispute between direct recruit and lateral entry. Not even promoted.
Just give us 1 minute, Mr.
Yes, yes.
Chaudhary. इनकी 2012 में अपॉइंटमेंट हो गई है। वो सब जो था ये उसको परमिशन से वो डिलीट जब हो गया तो वो फिर 2015 में इसकी सीनियरिटी उसी जगह वो क्या है हमारे से ना। Now let us see the rules, Mizoram rules.
Yes. Rules is at page number.
You appear for
5.
the direct recruits and Mr.
Inductive.
Inductees. Where are the rules?
Page 85. It starts. Now please come to rule 8 at page 86, Milord.
These are Mizoram Civil Service rules of 2000.
Yes.
Eight.
Recruitment to this service. Recruitment to this service.
That's part 4.
Page 86, Milord, part 4.
Part 4.
Recruitment to service in junior grade after commencement of this rule shall be by following method. 66/2/3 of the vacancies shall be filled up by direct recruitment through competitive examination
be conducted by Public Service Commission.
Yes, sir.
3 and 1/3 of the vacancies shall be filled up by selection from amongst officer who holds gazetted post in a substantive capacity in connection with the affairs of the state with not less than 5 years of service in such grade, and AOs with not less than 8 years of service shall be eligible for induction into the service by selection method for this quota in any manner as may be prescribed by MPSC. So, my lord, 66 2/3 direct recruitment and 33 1/3 by induction.
That's true. Now come to the seniority, how it is to be
Yes.
there.
Come to 91, my lord. Seniority inter se of the members of the service at its initial constitution shall be
1 second. I just couldn't come to that page.
91. my lord.
Yes, sir. '91, yes.
Seniority inter se of the members of the service at its initial constitution shall be as determined by the government in accordance with the orders and instructions in force before commencement of this rule. 2. Selection inter se of the members of the service appointed after commencement of this rule shall be determined by the government from time to
But
time in
nothing-
accordance with.
Where is the specification that the direct recruits have to be placed senior? At year, in that academy, in that,
There is none,
there is none.
there is none.
So on what
Only thing
ground?
will are to determine seniority, government will frame regulation.
There are no regulations.
Therefore, the safest way is who entered the service earlier.
No, there are no regulations. And now let us see the learned single judges
Yes.
logic. Born in the cadre argument many a times is not accepted.
So, my lord,
No, that's in your favor. Born in the
No,
cadre is
Supreme Court says
argument.
when there, in the absence of rule, the safest course is to go by who entered the service.
Which judgment was that which we decided and you argued and perhaps Mr. Das?
My lord, that was the case from PW department, where the vacancy arose, that was made decisive.
We have referred to those judgments in that
Yes.
case, no? Or judgment nikal
No, I have brought those, my lord, two judgments are there.
No,
But
let us see
but
what
to
we,
cover our
let us see
case, my
what
lord,
we did. We shouldn't go, I mean, we shouldn't have any different reasoning or judgment nikal dena. You have got that judgment also?
No, that I haven't brought. my lord.
Case number.
No, वो नहीं याद होगा उनको, how will he remember?
The
This
report
is,
नहीं होगा.
report नहीं होगा, उसमें से निकालेगा.
5th of February, my lord.
Mr.
DD
Chaudhary
Kaur
and
was
DD
there,
Kumar.
DD Kaur was there.
Huh.
Yes.
Yes.
Notun judgment, so we were not, I am not aware of it.
Let
My
us
lord,
see
the
the,
judgment.
let us
starts-
see the
Yes.
judgments of the, judgment of the single judge.
Yes. Now please come to page 197. Para 31 onwards.
197.
197.
1 second. Where does it begin from? So many cases they have.
The sentence starting with in the present case.
What judgment different proceedings, sale of Yes.
In the present case as well, the Mizoram Civil Service Rule 2002 and even in the subsequent rules of 2012, there is a fixed proportion quota meant for direct recruit and promotees to make their entry into the junior grade of the MCS. The claim for interspacing between direct recruit and promotee in seniority list is on the basis of the judgment rendered in NR Parmer, circulated through OM dated so and so. Apparently, the case of Marvin Coutinho and the case of Subba Reddy and another were not taken into account as was observed in Hariharan. Originally, seniority cannot be claimed from the date when the incumbent is not yet born in the cadre. But in the present case, there is no dispute to the fact that MPSC rules, the MCS rules of 2002 and even in the subsequent rules of 2012, provide the quota for entry into junior grade of MCS by direct recruitment promotee, and the criteria for fixation of interest with seniority holding the fill insofar as present case is concerned was the OM dated 4/3/14. A reading of the OM as a whole and the case of NR Parmer in the considered view of this court leaves no room for doubt that irrespective of dissimilarity in the dates of appointment between direct recruits and the inductee, their interest seniority will have to be fixed by interspacing them in the terms of the quota elected to both the sources by the rules. Although Meghachandra Singh has been recommended to be considered by larger bench in the case of Hariharan, but outcome of reference is not known. In this regard, it may be seen that Apex Court in Union Territory Ladakh versus so held as follows. We are seeking before us judgments and orders by the High Court, not deciding cases on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating to thereto is pending. We have also come across examples of High Court
नहीं, नहीं, वो सब तो
refusal.
ठीक है. Now let us see the rules, what has been relied upon. And what
This
is
case,
N-
Miller.
NPAR? The rules of 2012,
Yes.
rules of 2002,
Milord, let
2012.
me make one position very clear, Milord. Rules of 2000 and 2002 or 12, it does not say either that in case the recruitment is of the same year, the promote would rank senior. There's nothing like it.
No, not that. We are asking, the word used frequently by the learned single judge
Ah.
is interspacing.
Interspacing.
So
That quota and rota.
So interspacing, otherwise normally the rule is that, these rules which provide for a separate quota, they also say how the seniority list. is
How
to be prepared.
interspacing would be done.
How interspacing, three there, one here, it's like.
Sometimes 1:1 also, one one promotive, one direct.
I have never seen that.
Ah.
In my state, there is no such rule. The rule is only first three regular, then thereafter, or they say that if they are promotees, they will be ranked senior.
Normally, Milord, in service.
In
jurisprudence, fine.
PWD, the rule says that they will be senior. Any appointment made in the vacancy year, if there is a direct recruitment and experience,
Promoting
because of
ranks
the experience, it is there at the top. Only because these inductees got promoted late, whether they could be given that advantage, taking the accrual of the vacancy year in consideration. That is a different thing, but these rules we must, why the word interspacing was used?
Interspacing is an expression, Milord. Maybe it was during the course of hearing. It was evolved by the Honorable Court, Milord. But that interspacing word we don't find anywhere in the rules. Neither anything to suggest in the rules that any such,
Suppose on same date, the inductees and the direct recruits are appointed. Suppose they are born in the cadre at the same time.
absolutely.
Then how the seniority list,
is not
how the
without-
civil list?
For that, the state has to come up with the regulation. State has not come up. That's why they are following the central government circular.
What
But
is-
that was adopted subsequently, Milord.
What is the central government?
Yes.
2014.
If your lordship should,
Can we have a look at whether it refers to it or not?
Yes.
MCS
rules,
rules of
Milord, as a
2000.
whole.
Now, we want four things.
Yes,
MCS rules of 2002,
yes,
rules of 2012,
yes,
and then OM dated 4/3/2014,
14, yes,
and then NR Parmar, of course, we will require.
yes, yes.
Any subsequent judgment will be delivered.
Page 94, Milord.
Hariharan has been delivered. No,
Yes,
no.
Not Hariharan.
Hariharan. Has judgment been delivered in Hariharan?
No,
K. Meghachandra.
huh?
Meghachandra delivered.
No, Milord, in Hariharan,
Hmm.
Meghachandra was referred to a larger bench, but that judgment is not out. My lord, in my humble submission.
When is it coming? When is that judgment coming?
When is it coming? We don't know about. No, no. My lord, my humble submission is, subject to what your lordships may say, our case is exactly like Meghachandra. There, my lord, it was adopted on 1/1/18. In our case, it was adopted on 19/3/18.
I read a news in Live Law, or was it Bar and Bench, that all pending matters and references are being concluded. It has
Will I-
already been concluded.
Your Lordship, just kindly permit
Now,
me to
Mr.
place one paragraph from.
It is no question of, nothing is happening if the status quo remains. So let us wait for Hariharan's judgment.
That
Let it,
just, I just can, if your Lordship permit me.
is not completed, but
No, no, I
still,
think that your
with respect to
Lordship,
this proposal of
yes,
the
this
bench.
proposal, then it adjourns that till the matter is being decided by the apex court. That's what your Lordship is saying.
No, we are not saying that.
No,
We'll
because.
wait for some time for Hariharan for the reason that it is not causing any harm. At the moment, you people are senior, he is there.
No, there's a stay of the judgment.
There is a stay. So the civil list has not come out.
But there is a status quo to be maintained but the order is passed by this court.
We'll
Status quo.
decide what is to be done. But then difficulty is that then these reference, Supreme Court will say that when you knew about the reference, why did you decide? All principles, it will become very difficult. Once you point out that a matter has been referenced before a larger bench,
So
then
there should not be any difficulty. Hariharan is by 2 honorable judges and Meghachandra is by 3 honorable judges. And
nonetheless,
in view of the 1976 judgment, my lord, it is always safe for the High Court to go by the larger bench. Well, can I place one paragraph from Parmar and one paragraph from Meghachandra? I think everything will be.
all right.
Yes. Please have Lord Parmar first. Parmar is to Lord 2012 13 SCC 340.
ऐसे तो नहीं पढ़ा हूँ ना पूरा देख लो.
Please come to para 52, my lord. Para 52 and 53.
Yes, about it.
Having has a lots of got it.
Yes,
Page
52.
374, page para 52.
We used Jagdish Chandra Patnaik and
Having interpreted the effect of OMs dated 7/2/1986 and 3/7/1986, we are satisfied that not only the requisition but also the advertisement for direct recruitment was issued by the SSC in the recruitment year in which direct recruit vacancies has arisen. The said factual position as confirmed by the rival parties is common in all matters being collectively disposed of. In all these cases, the advertised vacancies were filled up in the original first examination selection conducted for the same. None of the direct recruit income tax inspectors herein can be stated to be occupying carried forward vacancies or vacancy which came to be filled up by later examination selection process. The facts only reveal that the examination and selection process of direct recruits could not be completed within the recruitment year itself. For this, the modification amendment in the manner of determining.
It doesn't tell us anything.
No, what I'm trying to say is,
Interspacing by what?
it's a judgment on the facts of this case. If I would humble request is some submission is, my lord, it does not lay down any ratio.
No,
Here in the rule itself says, here it says, my lord, the rule says that we are satisfied, please come to the second line, not only requisition, but also advertisement for direct recruitment is where SSC in the recruitment and in the direct recruitment vacancies has arisen. So here the rules provided. In our case, there is no rule. So therefore, the stand of the measure of government is they adopted me not the central rules, but central rule was adopted only after the.
But why was this argued and why not Jagdish Chandra Patnaik argued?
Yes. Jagdish Chandra Patnaik also, my lord. Then please come to the judgment of Meghachandra, my lord. 2025 SCC 689.
But in the absence of the rules, see,
My lord, my humble submission
Whenever there
is
is a
the
clear-
observations were in the facts of that case.
how to determine the seniority?
Not merely because direct recruitment was delayed. In that case, in the NR Parmar, direct recruitment was delayed, therefore they will not lose their seniority. Because the rules provided, but there is no rules. And the stand of the Mizoram government is, we adopted the central rules, it was adopted later.
Let us see Megh Chandra.
689, 2025 SCC 689. Please come to para 35 and 36 and 37 at page 701. At page 701. After the judgment in NR Parmar was delivered, the Union of India issued office memorandum dated 4/3/2014 defining the recruitment year to be the year of initiating the recruitment process against the vacancy year, and that rotation of quota would continue to operate for determination of their inter-state seniority between direct recruit and the promotees. This memo was not made applicable to the state of Manipur till the issuance of the OM dated 21/12/17, adopting OM dated 4/3/14 prospectively with effect from 1/1/80. Here in our case, my lord, it was adopted on 19/3/80. Significantly, the said OM specifically provided that appointment promotion made before issue of this OM will not be covered by this OM. Seniority already fixed as per the existing rules followed earlier in the state prior to issue of the OM may not be reopened. It was also specifically stated therein that this OM will come into effect on 1/1/18 with the publication in the Gazette. From the above, it is not only apparent that the above OM was only to be given prospective effect from 1/1/18, but it contains an express acknowledgement that this was not the position prior to the issuance of the OM, that a different rule was followed earlier in the state. The conclusion is therefore inevitable that at least prior to 1/1/18, direct recruit cannot claim their seniority should be reckoned from the date of initiation of the recruitment process and not from the date of actual appointment. Now this is important. When we carefully
Continue.
When we carefully read the judgment in NR Parmar, it appears to us that the referred OM were not properly construed in the judgment. Contrary to the eventual finding, the said two OMs made it clear that seniority of the direct recruits be declared only from the date of appointment and not from the date of initiation of the recruitment. Kindly take note of one thing, my lord. NR Parmar was by 2 honorable judges, and this is by 3 honorable judges. That's why these para 37 observations are also very important. Now in the facts of this present case, if your lordship should the other file, there's one document in the other file. Now before that, if your lordship should kindly come to 177. If your lordship should kindly come to page 177, my lord. This is the OM which government of Mizoram professes to apply, my lord.
OM of 2014.
Yes, page 177.
You have a separate pull out.
No, here we haven't made a separate compilation. No, my lord, for this file only. I only refer to one document from the other one, that adoption order.
Page 100.
177.
इसकी photocopy बना कर लेना.
Now, if your lordship would kindly come to page
No,
177.
let us see the
Yes,
first paragraph.
prefaces. The undersigned is directed to refer to the subject mentioned above and to say that the fundamental principles of inter-state seniority of direct recruit and promotee and central civil service posts were laid down in the Department of Personnel Training, OM dated 29/12/59, which provided inter alia that relative seniority of direct recruits and of promotees shall be determined according to rotation of vacancies between the direct recruits and the promotees, which shall be based on the quotas of vacancies reserved for direct recruit and promotion respectively in the recruitment rules. So this is how it proceeds, my lord. If a lordship would kindly come to page 178, referring to my lord NR Parmar judgment, para 5 on top. The matter has been examined in pursuance of the Honorable Supreme Court judgment dated 27/11/12 in civil appeal number so and so in the case of Anna Farmer in consultation with the Department of Legal Affairs, and it has been decided that the manner of determination of interest seniority of direct recruit and promotees would be as follows. Now, amongst others, these are the Millard criteria laid down. If your lordship would kindly come to page 179.
No, please, you
Yeah,
don't
okay,
believe
okay.
that. We want to
Yeah,
read
yes, yes.
this. Now read B.
The rotation of quota based on available direct recruit and promotee appointed against the vacancies of a recruitment year as provided in DOPT dated so and so would continue to operate for determination of inter-se seniority between direct recruit and
Yeah,
promotee.
this does not talk, this is a recruitment year. So recruitment year is not recruitment, the vacancy year. So, this is a point where I would interest based. Yes, then
Now, if your lordship would
no,
kindly.
the C, the available
C.
that.
The available direct recruits and promotees for assignment of inter-se seniority would refer to direct recruit and promotees who are appointed against the vacancies of a recruitment year. Recruitment year would be the year of initiating the recruitment process against a vacancy year.
The recruitment year would be the year of initiating the recruitment process against a vacancy year. So the vacancy here, now all these principles therefore have to be, eclipsed for the time being, so far as your case is concerned.
Yes.
Because this is 2014.
Okay.
This is the circular of the Mizoram government
Yes.
after Parmar's judgment. So therefore, then the board indicator argument would not be available to you,
No,
no?
Lord, my argument is page 179. Please come to page
Achha,
179.
therefore read the whole of it, initiation of recruitment process.
Yes.
Now read the whole of it.
Achha, okay. Initiation of recruitment process against a vacancy year would be the date of sending the requisition for filling up of vacancies to the recruitment agency.
Yes,
In
sir.
case of direct recruitment, in case of promotee, the date on which the proposal completed in all
So
respect.
they are very specific now.
Yes, yes. Now it's very specific.
Very specific. Now
There
it
is
is not,
nowhere
it is
to-
not that PWD
no-
matter where
nowhere to-
everything. Now for
The-
direct recruits,
Yes,
is the requisition.
yes.
In case of promotees,
When
when
the
the proposal is complete,
proposal is
everything
complete,
done.
is sent to the Public Service Commission. The initiation of recruitment process for any of the modes, direct recruitment or promotion would be deemed to be initiation of the recruitment process for the other mode as well. Carry forward of vacancies again, direct recruit or promotion quota would be determined from the appointment made against the first attempt for filling up the vacancies for a recruitment year. The above principle for determination of inter-se seniority of a
68 2/3 रहेगा और फिर
I know,
33 1/3.
this committee meeting is following. I'll come. The above principle for determination of inter-se seniority of direct recruit and promoted would be effective from 27/11/12. That is the date of Supreme Court judgment in the case of Anal Parma. Then kindly see. Cases of seniority already settled with reference to the applicable interpretation of the term availability as contained in DOPT dated so and so may not be reopened.
आपका कब
पहले से इसका promotion.
when were you inducted?
No, I'm not inductee.
No,
Because
when were you recruited?
We were directly recruited in Milot 2012 and they were inducted in 2015.
No. Let us see the recruitment year first.
Yes.
So far as your
Initiation was same year,
2012.
but the proposal was dropped.
We have
Then
followed.
subsequently revived.
We have followed that, Mr. Chaudhary. Now let us have the facts correct.
Yes.
Your
Can I give the dates, Milot?
yes.
Kindly see, Milot, 9/8/2010. Requisition by government to Public Service Commission for the direct recruitment 10 posts, induction 5 posts. My Lord, following selection by the MPSC on 16/4/12, the appellants were appointed. Lord, 10/5/2011, Personnel Department withdrew the proposal for induction of 5 posts. In the meantime, my lord,
No, we drew the file and then what happened?
no, I'm giving the facts, my lord. Then, my lord, two aspiring officers, they filed a writ petition. That is WPC number 127 of 13. In that judgment, in that case, the single judge of the Honorable Court, my lord, passed an order to consider their cases as per the old rules.
No, rule,
No, no.
rule is the,
And lots of will have the
they would have
case.
said that why was it withdrawn?
That we don't know, my lord. That
Why was
whatever
it
it is, it
withdrawn?
was withdrawn.
Withdrawn reason is given, withdrawn for the reason that MCS rule is being formulated. That is the reason, that reason is there.
That's in his favor, no?
That's it.
Then we can see the cooking rate khatam ho gaya.
Anyway, then, my lord, thereafter, my lord, selection took place. And on 15/1/15, respondents number 4 to 8 were inducted laterally.
This,
15/1/15.
this fact alone will not let us decide. Now, the file was not withdrawn, it was deferred.
No, my lord, it was withdrawn.
Respect, see, the
Page
vacancy,
104, my lord.
1 minute, the vacancies remained the same.
Yes, correct.
Right. So for the counting of that vacancy, the recruitment year would be when it is sent.
Correct.
Ah,
Going by that 2014 circular.
Withdrawn case, proposal case, that was citizen. Those proposals will set aside and their cases will be rejected. We can.
Can we have the judgment of that case, no? Judgment of that single judge? Was the
127 to
petition to recall
It
set
is there,
aside?
my lord.
set aside.
Page 180.
Yeah, 180 is the impugned judgment.
No, the judgment in the 200.
Oh, I'm giving, I'm sorry.
127 of 2013.
127 of 2000.
I think it's 106. 106, my lord.
23/7/2014. Then 2000.
Yes, yes. 106.
Recruitment year. 106.
If your lordship should kindly come to page 115, the operative portion, my lord, para 12 and 13. In the present case in hand, the amended rules of 2002 was in force when the notification dated 19/11/2010 was issued. It was therefore incumbent on the respondents to have considered the case of the petitioner under the amended rules of 2002 and not otherwise. This is a settled position of law. In view of above, this court does not find any necessity to make any further discussion, but to direct the state respondents to consider the case of the petitioner strictly in accordance with the provisions provided by amended rules of 2002. Such.
So therefore, under the directions of this court, the vacancy year remained 2010. But the counting of vacancy year according to 2014 OM which you read is when it is sent. So this, the vacancy year and then the requisition, they started in 2011.
Correct.
As it was started with you. So therefore, why should they not be relegated to the same vacancy year and then what NR Parmar says and what Meghraj says? So that becomes very clear because 2014 applies.
Yes.
Oh,
No,
there.
2014 will not apply. As it-
2014 will not apply because of the last thing that it is before. We have followed, but it was never decided. No, it was never decided. Question is that has it been decided? No, no civil list came. So
No,
this, So therefore there
No,
was,
seniority list, consolidated list is there.
no, your merit list would have been there.
No, my lord.
See, how can it be?
No,
You were appointed, look at this.
No, all that I'm saying is, my lord.
You were appointed in 2012.
Yes,
They were appointed in 2015.
15.
With
So,
res-
so in the seniority list, therefore they were shown below us. That's
Senior-
what they challenge.
Oh, that's all right. So therefore, that was not the civil list. That was not a seniority list.
No, I understand. my lord.
They-
You
they
know
were
what you mean by civil list, yeah.
I'm talking about civil list. There is a difference between
Yes,
seniority
civil
list and
list is
civil.
not out, I'm sure. no?
Civil list is not out. So therefore, whether the last clause would apply.
Yes. Absolutely.
What is the position of law? We must appreciate.
So we have seen by now, my lord. It seems.
Then 2014 rule applies proprio vigor. Prima facie. Don't think that we'll hear him also.
Yes.
That's the question. So therefore, now this has to be worked out. Now, if this has to be worked out, then Justice Silo's judgment should not be interfered with.
That is the position. So, my lord, I'll show from the. my
See,
lord,
there is one judgment which makes it very clear. Now, the inductees recruitment process was derailed on the
For
ground that
whatever reason.
for the reason. The reason has been found to be wrong. The reason was that now we are amending the rules. Now, Justice Jamir says while hearing the matter in 127 of 2013 that, well, the rule is, and he quotes that judgment which is often quoted with respect. The rules of 2002, amended rules of 2002 will apply. So therefore, once the vacancy year recruitment process was begun, merely on the ground of there being change in the rules which is contemplated, you can't stop it, you can't derail. So therefore,
Question of 4314 applying would depend on when the government of Mizoram adopted it.
the government of Mizoram may have adopted, may not have adopted.
No,
but
no.
the difficulty is
If they
that
have not adopted, how can
they-
that, then Meghraz will have no value, my lord.
no. See,
That's
they,
why I said in Meghraz, the
2004
adoption was 1118 and over here it is 19318.
19318, we
That's
have,
why, can you give that other
you-
file?
no, but okay, we have followed
I'm
that.
just showing that document. my
That
lord.
is the only argument.
Yes.
Now, that is the only argument that this
Yes,
will not
yes.
apply, and therefore there are
And in
no,
fact, that
and
our
therefore-
whole case hinges on that.
and therefore there are no rules.
Therefore, no rule.
And therefore born indicator rule.
Yes,
That
yes.
is your argument. Otherwise argument is.
Yes, yes. Page kitna tha? 228. Please come to page 228, my lord.
Of which file?
A second file. my lord. Department of Personnel and Administrative Reform is advised to consider fixation of seniority of
Yes, sir.
officers in the junior grade of the MCS
It
as
is
per
not-
the instructions contained in
No.
para 5 of DOPTOM dated so.
बहुत मुश्किल है. Now this is no way of effecting it. It only says it's an advisory. We have not effected it, but you please take it into
No,
consideration.
my lord, then some meaning has to be given to my lord, the Meghraz judgment. Please have Meghraz judgment for a moment, my lord. Para 35.
मेघराज निकाल कर दो ना. इसको
Para 35.
इसको यहाँ फ्लैग कर दो और मेघराज दो इसको. That is only for this.
My lord, 2025 SC 689.
Which paragraph?
35. After the judgment in NR Parma was delivered, the Union of India issued the Office Memorandum of 4314 defining the recruitment year to be the year of initiating the recruitment process against the vacancy year and that rotation of quota would continue to operate for determination of inter-shift seniority between direct recruits and promotees. This memo was not made applicable to the state of Manipur till issuance of OM dated 21/12/17, adopting OM dated 4/3/14 prospectively with effect from 1/1/18. Significantly, said OM specifically provided that 5(1) last clause. Appointment, promotion made before issue of this OM will not be covered by this OM. The seniority already fixed as per existing rules followed earlier in the state prior to the issue of this OM may not be reopened. It was also specifically stated that this OM will come into effect from 1/1/18 with the publication in the Gazette.
ये तो this is वो तो अभी भी नहीं आया है. This rule, if we take it that way, then this 2014 has not yet been gazetted.
No, they have adopted at page 228.
Adopted का वो gazette में adopt करना है ना?
I will not.
They have to adopt it by gazetting it.
Yes.
So this is just an advisory.
So then will not.
That is a strong.
Then will not, how can this 4/3/14 be applied? Because Lordship is trying to draw an
The general
inference.
principle of quota rota.
No, principle of quota rota they have to apply. The regulation has not been framed by the state. So what does the Supreme Court say then, Milord? In the absence of any rule, the safest course is to go by the date of entry. No, otherwise, Milord, I cannot.
Why can't Mr. Das argue that the safest course is to go by this rota quota vacancy here? Because suppose the civil list were to be drawn today.
We cannot just pick it up from thin air and apply, Milord.
No, it's not from thin. It's not a. I'm telling you, Mr. Chaudhary, it is not a low-lying fruit.
No,
See,
no,
we may pull the branch and then make it low-lying for us to pick it up. Now take it like this. If we say, I mean, we are all testing it from all angles. None of you are losing out substantially. You remain in service. It's just the seniority, few of them. Now look at this. Now, with the appointment in 2012, your name found mention in that list. But till date, the civil list has not come. They can't be said to be the recruitees of 2015 with that judgment of Mizoram. So they remain the recruitees, I mean the inductees of the year 2010, 11, whichever, of your vacancy. In that case, the seniority, they were never born in the cadre, correct? So seniority is something list when two sources merge. Now suppose they were also, if they had come late, maybe this the born in the cadre argument would have been more convincing. But here they enter only in 2015. The recruitment year doesn't change. Now, if the recruitment year doesn't change, then the civil list has to be prepared. Otherwise, you will not. So what is the meaning of giving them the same recruitment year?
I do agree.
Interest.
But the recruitment year, where from we are getting it, Milord? Merely because central government circular is there.
No, NR Parmar.
No, NR.
This circular is based on NR Parmar.
But NR Parmar is a decision rendered on the facts of that case.
Right.
There the
But
recruitment rule and vacancy here was, laid down.
Correct. But we are looking at it from a different point of
So,
view for
I am trying
generalization.
to find out when the government of Mizoram has no seniority rules. Can we say the central government rules will
Even-
apply by default?
No, we can't say that.
Yes.
Therefore, we are employing this logic that the rules are absent. But for some quirk of fate or circumstance or judicial interference, these people, these inductees are also now to be treated as 2014, 2012 or 2011 inductees. Correct. So civil list up till now has not come.
Yes.
So if up till now it has not come, then seniority list has not been formulated. It will be formulated only, and this is post 2014.
Then Milord, until
Hey,
this
suppose
comes out, the seniority list will continue.
What seniority are you referring to is just the merit list.
Not merit list,
It
Milord.
is not a seniority list, because you see,
Yes.
you argue anything from the General Clauses Act or from service jurisprudence. What is the difference between a civil list?
Civil list, that I have to say.
So civil list has not been made up till now. What isko kaise overcome karenge?
If civil list is not published, then the repetition was premature. Why has the learned signatures answered it? If that is the understanding.
Today
Milord,
also we are.
then learned signatures will have refused to answer the repetition.
No. Learned single judge applied a different logic.
Ah.
He applied the logic of 2014
Yes.
and Parmar.
Or not.
did not look at that particular clause which says that it shall not apply. Correct. But what can we not read it as if sub silentio?
Yes.
So sub silentio is there that the civil list was not prepared. Therefore, now you are preparing the list. Give the seniority. This is Mr. Chaudhary's clients are only in the seniority in the merit list which they have come. That's not the seniority list. So how come seniority list will come?
And my lord, there is one.
Then you have a problem there.
My lord, there is a division bench judgment of our High Court. As of the moment.
बहुत लॉजिक वेदा उधर घुमाए करना पड़ा ये तो आसान बोल रहा
7,11.
Yes, my lord.
My lord, before my learned friend, because my learned friend started, I had the judgment, I want to cite first the judgment. Because the time when the matter came up, initially before this court, and my learned friend wanted a stay of this matter, but then the court said that we have a judgment of our court, please look into this. Honorable Justice Bisnoy was there in this case. No, this judgment of a coordinate bench judgment. Now they relied on the judgments. They relied on the judgment. Then I pointed out about the judgment of Marlene Miller, rota quota system. Then the court said we have to hear this matter. So accordingly, matter has come up and there is a status quo which was granted by this court.
Now, this order, my lord, kindly have paragraph 15. In the meantime, a 3 judges bench of the Honorable Supreme Court in Meghachandra reported that so-and-so has revisited the decision of the Honorable Supreme Court in case of N.R. Farmer, which was delivered by 2 judges bench and has overruled the same decision. At the same time, it has been made clear that the decision in Meghachandra will not affect interstate seniority already fixed based on N.R. Farmer and the same are protected. Relevant paragraph of the decision in so-and-so. At this stage, now the petitioners have filed this writ petition assailing the validity of the order dated 4/8/17 passed by the tribunal contending that in view of the decision of the Delhi High Court in so-and-so and later by the Supreme Court in K. Meghachandra, whereby decision of the N.R. Farmer has been overruled, the decision direction given by the tribunal in the impugn order cannot be implemented.
How does it?
It is also contended on behalf of the petitioners that though initially the petitioners had started the exercise of assigning seniority to income tax officer as per the direction.
That's all right, Mr. Chaudhary. We are appreciative of this judgment.
Yes.
That
20 and 21 last.
we have seen that.
As we have already noted that the judgment rendered by the.
We are on that judgment. We are on that paragraph only. See, here the question is totally different. I am on a different issue.
No, follow. My submission is also very simple. Now, my lord, if we go by the mandate of 14th Circular of Government of India, then certainly we don't have a case. Let us be very clear about it. In which case, recruitment here is sent. No case in the sense now that civil list has to be published and the
Now, therefore, the thirst.
that slots has to be
Therefore,
asserted.
this thirst which was not there anywhere in 2013 Justice Jameer's judgment or Justice Silo's judgment or in Justice Vishnoi's judgment, we tell you that we are looking at this entire episode of
From that perspective.
seniority from the perspective of a civil list not having
Yes,
come
yes.
out. So in that case, whether OM 14 would apply or not, because now the civil list is to be prepared. It was only your entry.
Now, when the civil list is to be prepared, now whether as per Rule 26, the states should come up with a regulation or.
No regulation also,
Huh.
if we hold that 2014 will apply here because civil list has not been prepared, then where is the difficulty? Then it has to be interest-based. Look at it. I mean, we are not pinning you down with this statement.
My lord, whether in such a situation, in absence of any specific prescription, whether 4.3.14 can be applied Lordship will give me some time, I would like to address. your
Definitely,
lordships on that
because
point.
now we are, देखिए,
I followed.
no, let me use my original vernacular kind of an expression. If आप आगे तभी बढ़ेंगे जब हमारे हाथ से ये नब्ज अपना छुड़ाएंगे, ये मैं पकड़ा हूं आपकी सिविल लिस्ट, अब इससे अब बाहर निकलिए, then you can argue. This is our vernacular thing that, see, vernacular is different. They say that you first go for the jugular. The jugular is here, but this becomes very bad, this can be taken as a different thing that he caught hold, stranglehold. Now this is पकड़ना इसको, तो इससे निकलिएगा, हाथ छुड़ाइएगा तब तो. Now I am on civil list. Civil list has not yet.
Now, for framing framing the civil list, what criteria is to be followed?
That's why the argument is very simple. See, it's always better to reduce it to simple formulas. Question is,
What logically follows?
what logically follows? We can't just cut it into. There's no Procrustean method.
The simple case which I was trying to argue before your lordship.
Yeah, you're right.
In view
That
of
argument-
the judgment since.
That argument is very, very conclusive, very convincing, no doubts about it. That all this apart, the Mizoram rules does not say. All these came later. You entered service in 2014, 2012. You were there. Now 2014 application, 2014 OM will not apply to you because Parmar says that it shall not apply. This is confirmed by even Meghchandra. Meghchandra says that it was gazetted in Manipur in 2018. There is no difficulty in understanding this. It's as smooth as running water of Brahmaputra. Nothing, no problem. The difficulty here is that things are not settled. If we see it from a smaller aperture, your seniority list is before us. Your merit list, not seniority list, your merit list is before us as a direct recruit. In that case, whether 2014 will apply or not, you can address us.
Yes, I'll do that.
Yes, your work has been done by us.
That's okay. I was keeping quiet, so you don't have to say much.
Do I make some?
You might have to on the next.
No, my lord, that's honestly, I never thought of what your lordship has said about civil list.
No, it
Honestly,
it
civil list.
It
Very,
struck
very-
me just now.
Yes.
Not
But so far as, my lord, I would have addressed your lordship. My lord, if I are addressing to N.R. Parmar and said nothing has been laid down, only paragraph 54, he was relying, it's not that case. N. Parmar, please look into para 34, how it was dealt with.
637.
No,
But
The lordship will have the date after Bihu.
we will definitely. I mean, there's no hurry as such. Only because of the fact.
Now, but the problem is not the promotional problem, Mr. Because we are stuck, my lord, because now interspace, we are saying that we have been appointed in 2015. We want an interspace with them in 2012. That's the whole problem, my lord. We will retire.
In the
That's
present set
problem,
of
my lord.
appeals, all right. In the present set of appeals, the appellants who are the direct recruits to the junior grade of Mizoram Civil Service / MCS have challenged the judgment dated 25th of March 2025 passed by a learned single judge in WPC number 127 of 2019. The appellants were recruited in the year 2012 against the vacancy arising in the year 2010, when a requisition was sent by the government to the Public Service Commission to conduct the recruitment process for direct recruitment. Simultaneously, such requisition was also issued for the promotees to the post.
Not promoting, they say inductee.
Sorry,
In
inductees.
the rules, there is no promotion, inductee.
All right, inductees. For inductees, however, the process with respect to inductees was withdrawn in the year 2011 for the reason of a contemplated change in the rules. Some of the inductees challenged the aforenoted derailment of the induction of the recruitment process with respect to them by WPC number 127 of 2013. It was held by a learned single judge of this court that since the rules of 2002, MCS rules of 2002 were in operation and the vacancy had arisen in the year 2010, the process which had been started could not have been derailed and it ought to be completed in accordance with the existing set of rules. As such, even though the process of recruitment of inductees was delayed, but they also stood inducted sometimes in the year 2015. The dispute began with the government fixing and interspacing the seniority with respect to the appellants who were recruited in the year 2012 against the vacancy of 2010, against the vacancy arising in 2010, and the inductees of 2015 who also were recruited, so to say, against the same year vacancy. Since the inductees were placed junior to the direct appointees / appellants, such seniority fixation was questioned by few of the inductees, wherein a learned single judge of this court, as noted above, directed that since the OM of 2014 spells out the procedure for interspacing seniority amongst direct recruits and the inductees, was applicable, the seniority list prepared by the government was faulty. The same was therefore set aside with a direction to recalibrate the seniority, keeping in view the judgment, keeping in view the principles contained in OM of 2014 and the judgment of the Supreme Court in NR Parmar, jo bhi hai, so and so.
NR Parmar Miller. 2012, 13 SCC 340.
NR Parmar dekh lo.
2012.
Challenging the aforenoted judgment, Mr. Kamal Nayan Chaudhary, senior advocate for the appellants, has submitted that OM of 2014 is very specific in its content and reach, which circumscribes its application to the seniority list already settled before such OM was issued. He has further submitted that the OM of 2014 was adopted in the state of Mizoram in the year 2018.
18, my lord.
in the year 2018. After having gone through the rules, after having gone through the Mizoram Civil Service rules, what what appeared to us today during the course of deliberation is that there was no, that no civil list as yet had been prepared, thus leaving the field open, thus leaving the slate open for the complete applicability of OM of 2014, notwithstanding its क्या कहते हैं उसको? It was notwithstanding its adoption in the state of Mizoram in the year 2018. In the year 2018. This juncture, Mr. Chaudhary, London senior advocate, sought for some time to look into this aspect of the matter before finally addressing the issue. Mr. Diganto Das, Learned senior advocate, has appeared on behalf of the respondents. Respondents slash inductees. Re-notify or give a date of your choice.
Lord,
अब जरा सिविल लिस्ट पर भी बहस कर लीजिएगा. ये इसी
Put it on, my lord, 12th of May, my lord.
It will be too long. Too long.
No, no, no.
Let
Actually,
it be on 26.
no, my lord, the first week, my lord, I'll be in Supreme Court, those CA matters are fixed from 3rd and 4th.
So anytime.
28.
That's why I said, my lord, 12th.
12th of May, 19th of May, subject to your convenience,
Yes,
Mr.
yes,
Das.
yes.
Yes.
हाँ चलिए 19th of May. Do one thing, वो परमार और वो दोनों जजमेंट की फोटो करके इसमें रख देना, जिससे जिस समय हम फाइल देखेंगे तो हमको याद आए. What's the next matter?
Next matter is item 8.
It's an item number 8. Yes, we'll come back after 5 minutes. Yes.
May it please the lordship. Lordship, this appeal arises from
Yes, yes, continue.
disciplinary
Don't
proceedings.
get distracted by our movements.
Yes,
We
Your
do
Lordship.
many things. Multitasking is there, no?
Yes, Your
Yes.
So this appeal arises out of a disciplinary proceeding initiated, which culminated in the appellant's dismissal from service.
Yes.
And the foremost ground of our challenge is basically, there were two other officers, senior in position, who in our submission were in the same footing in that there were similar charges. They were facing similar charges, but they got a lesser punishment. So the issue really is if there is any material distinction in relation to the irregularities to warrant a disparity in the punishments.
Okay.
Lordship, the single judge held, may I take you to the single judge first and get it out of the way? Page 593, two findings which we are agreed by. Second volume.
Second volume, na? Same volume.
Oh, sorry, my second volume. I can.
Mr. Ordinary. Did we hear it? No, no. Did we hear it?
No, Your Lordship. Notice was issued.
Oh. Similarly situated persons were treated differently. Quantum of punishment. Yes. How has it been dealt with?
Yes, Your Lordship. The single judge starts at 564. The two findings that we are agreed by is at page 593, paragraph 28.
564.
It starts.
Judgment.
Judgment, yes.
Tell us the internal pages also.
Okay, page 1.
But
I'll tell
of
you.
the judgment?
Yes, page 31.
Paragraph 28.
लेकिन अब यहाँ उपलब्ध नहीं है। Is 31.
Page 31, below.
Yes.
Lordship has paragraph 28.
Yes.
May I read?
Yes.
Reading the aforesaid chart, it appears that out of 16 irregularities alleged against the petitioner, within the subject charge sheet, 12 have been proved. It further appears that out of 10 irregularities alleged against the co-delinquent, Ashapurna Sinha, 6 have been proved. It further appears that out of 9 irregularities alleged against the co-delinquent, Haskar Datta, 3 charges have been proved. It further appears that though the incident in relation to which the aforesaid charges have been leveled against the petitioner and the other co-delinquents is same, there appears to be a material distinction in the case of irregularities alleged against the petitioner as compared to the other delinquents. So single judge has found material distinction in the irregularities.
Complete the paragraph. I cannot.
Sorry, Raj, I cannot also be unmindful to the extent of lack of verification in the case of petitioners, which is of a much higher standard considering the nature of job as a field officer at the relevant point in time compared to the other 2 delinquent employees. That apart, it is apparent that from the above comparative statement that the gravity of charges leveled and established against the petitioner is much more serious and grave compared to the other 2 delinquents. Hence, the charges leveled against the petitioners and the other 2 co-delinquent cannot be said to be same and identical. That being so, the principles of clarity cannot, in the facts of this instant case, be attracted. I am thus of the unhesitant view that there has been no discrimination meted out to the case of the writ petitioner, and penalty imposed upon the writ petitioner appears to be proportionate to the gravamen of the charges established. Lordship, I will also read paragraph 29. This is on perversity. Though the learned counsel for the writ petitioner contended that the impugned inquiry is perverse, the report of the inquiry is based on evidence, and the adequacy of the same cannot be gone into by this court under Article 226. And Lordship may read this with page 574. I'll tell you the internal page. Paragraph page 12. Paragraph 9.
Yes.
Just to show how much of the evidence the single judge perused. Lordship, I'll read paragraph 9, but I'm relying only on this is the extent of inquiry into what the inquiry officer did. Reading the aforesaid, may I read paragraph 9? Lordship has paragraph 9.
No,
It's internal paragraph page 12.
just come to it. Yes.
Reading the aforesaid 16 allegations and charges contained in the statement of imputation of lapses against the petitioner, it appears that the petitioner has been alleged to have committed irregularities while performing his duty as a field officer, for which the respondent bank has allegedly suffered a pecuniary loss to the tune of 205 lakhs, besides reputational loss. Upon appointing an inquiry officer, the inquiry was held against the petitioner, wherein admittedly all requisite opportunities as required were afforded to the petitioner. The inquiry officer, after completion of the same, submitted its report on 3/9/19. Perusal of the inquiry report, it is apparent that the findings of the inquiry officer are based on evidence. So this is the inquiry that the single judge has conducted. He has gone through the inquiry officer report and he says the findings are based on evidence. Lordship, while we are at this single judge, may I take you through the rules because he's extracted them. Lordship may take a look at.
Paragraph 15 is extracted 19.3.
Yes. 19.3 is important is because while the articles of charge framed in February 19, the appellant retired on 28th of February. So these rules says that notwithstanding retirement, if a disciplinary inquiry has been initiated, it will continue even after retirement. Lordship, paragraph 18 is the charge, and I will take you to the charge. Rule 54. 54.
Yes.
Every officer shall at all times take all possible steps to ensure and protect the interests of the bank and discharge his duties with utmost integrity, honesty, devotion, and diligence, and do nothing which is unbecoming of an officer. This is the primary charge, violation of this rule, which is followed by a list. Lordship may now have the penalty, which is what our grievance is. Paragraph 19, the very next paragraph. The list of penalties to be imposed on an employee of the respondent bank for an act of misconduct under Rule 40 of the existing rules is provided under 67. Lordship has 67.
Yes.
Without prejudice, your lordship, minor penalties. All three of them have been inflicted with major penalty, while Bhaskar Datta and Ashapurna Sinha is inflicted with F, which is basically, your lordship has F.
Reduction in a lower time
Yes,
scale. Oh,
that-
followed.
We have got J, which is dismissal without any retirement benefit, pension, gratuity, nothing. And our grievance is that considering allegation is similar, same. There is no material irregularity in the charges to warrant a disparity in the sentence, in the punishment. And lordship has page 730, which is what it, I take it to lordship, it basically means that we don't get any benefit except my contribution to PF.
Oh, that's right.
Yeah,
Yes,
that
there
is-
it is now.
So this is what it is. Lordship, for sake of convenience, I made a note. May I? Chat on a detail. And I've referred to all the page numbers. So Lordship, the issue is there a material distinction in relation to irregularities committed by all three officers to warrant a disparity in the punishment? That's the core of the thing. If I can show you, Lordship, that there isn't, then the disparity in sentence is arbitrary and unjust. Lordship, I have quoted the
It's a very
part,
uphill task, Ms. Gayatri.
but I will
Now,
try
many-
my best.
Many of
Yeah.
the charges were not proved against some of them.
Yes,
And
Lordship.
then you have a special responsibility
Yes,
as a field
yes.
officer.
Yes.
Can we get into it?
Lordship,
That's the whole difficulty.
yes,
Well,
yes, which is why I have simplified it
Oh.
as much as possible. If after this, your lordship, I cannot convince
Now,
you,
we
I will
are
leave it to your
always
lordship.
reminded of that observation in Gunasekharan. They say that it's a very unpleasant experience seeing the High Court get into all this like a court of appeal.
No, lordship, I'm not asking you to reappreciate. But what the Supreme Court says is that infirmity must be more than ordinary. That is all that I'm placing before you. That the infirmity in the,
You can argue Ranjit Thakur, shocking to the conscience.
yes,
but
yes, your
really,
lordship, yes, your lordship,
But
yes, yes.
I don't think we-
2024
I
says,
don't think we'll agree with you on that.
lordship will hear me still?
Yeah, we might
Obliged.
change our opinion. We might change our opinion.
Yes, your
anyway.
lordship.
Midway, up till now, we have not been
Yes,
able.
your
to.
lordship. I will attempt, your lordship.
Yes,
This
yes.
is the purpose. This is more to simplify for myself, and I thought it might just help simplify.
It does
Your
good,
lordship.
good for us also.
So lordship, the charge is this. May I read the charge?
Yes.
I've quoted it during your tenure as a field officer. So I was a field officer at Dadra branch from October 17 to August 2018. Certain serious irregularities were alleged to have been committed by you, and due to such irregular activities, the bank is exposed to suffer a pecuniary loss to the tune of 205 lakhs besides reputational loss. You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per the bank's exact
Extent norms and
extent,
instructions.
norms and instructions. These acts are unbecoming of an officer. In this manner, you have violated Rule 54 of the SBI rules that is applicable to you. Imputation of lapses.
All right. So these
Yeah.
were identical with respect to
Yes,
Bhaskar Datta and Ashapurna.
Your Lordship. And then the next bullet is, while Mr. Datta and Sinha were examined as witnesses in the proceeding against us, and you'll find that in page 505, appellant was never examined in the disciplinary proceedings against Datta and Sinha. That apart.
No, can that be a ground? I don't think that's a ground.
It's information, Your Lordship. You have just put it up.
That's for Ashapurna or Bhaskar
Yes,
Datta
correct.
to complain
Yes.
or not to complain.
complain.
And that's for the department,
Yes.
that's for the bank. That's
This is
basically
fact.
their proceedings.
Yes, I'm stating the facts. And Ashapurna Singh is the chief manager who's the controlling authority, and Datta is the assistant bank manager who's the sanctioning
Oh,
authority. So-
herein lies the difference. No, this is what struck the court.
Yes,
Your
Your Lordship.
argument was absolutely all right. Parity has to be shown, but parity with respect to the responsibility.
Yes.
So
yeah.
there the field officer does, these were all, just to step up, ramp up the statistics. that
Correct.
so many loans
Yes.
without caring for the details, and all those loans went bad and there was a loss.
Yes.
Even there were persons against whom loans were
Third
given,
parties.
though
Third
non-existent,
parties, third parties,
non-existent
third parties.
persons.
Correct. Your
So
Lordship.
this would depend on the reporting of the field officer.
Yes.
So that way,
Not in, Lordship, may I take you to the chart?
no, we are not stopping you.
Yes, Your
Actually,
Lordship.
we are only giving you our reasons up till now. So we
Yes.
keep on giving. It's a
Yes.
simultaneous
Yes,
exercise.
yes, Your Lordship.
Mhm.
I'm hoping that this note will
Mm.
answer few of the
Mm.
issues, or at least handle, attend to few
Mm.
of the issues.
Mm.
Allegations are also again factual.
Mm.
Total 16 allegations against the appellant, 3 proved, 2 partially proved, and 11. Lordship, I'll not bother you with the allegations. This is a matter of record. Now what comes is important, Your Lordship.
Out of 16, 12 approved.
Yes.
Hmm.
Now, Lordship, what I have done is, for the sake of trying to find out, just saying that 3 are approved, 2 are approved, it's a number. At the end of it, what is the charge that is, what is the meat of the charge at the end? So I have divided my note into what was proved against all, what was not proved against me, and what was proved against me. Because what was proved against me must be such to warrant a disparity that if from F to G, the gravest. The Lordship now has allegations proved against appellant and the 2 officials. So Lordship be mindful that I'm not the only one party to it. Everybody else, Ashapurna Sinha, and because we're on parity, Ashapurna Sinha and Bhaskar Datta, these charges, and Lordship be mindful, when I say Roman 1, Roman 2, it is, if you read, I've also done this exercise, basically corresponding charges, because they've done it differently. I am now only on Ashapurna, so I will deal with the Romans of Ashapurna's charges. One pertains to Ashapurna Singh, but I've given the pages.
Mhm. Yes, you are.
So the first allegation is 927 of 968 Kisan credit card loans were sanctioned at the bank and disbursed in cash when KCC circular required that borrowers shall be issued ATM enabled KCC rupee card. This particular thing of disbursement in cash without issuing an ATM has been held to be proof against all 3 officials. Lordship will find that at page 506, 431, and 448. So the allegation that there has been cash disbursals, there has been non-conformity to circular of the bank, and there has been no ATM, KCC rupee card has been proved against all.
To that extent, we can understand Ashapurna was the controlling authority
Yes.
and Bhaskar was the sanctioning authority.
Yes. So they
They were
knew that
separately
the statute,
charged.
they knew that
All the
927
All
of
the
the
reports,
968
all the reports were Gayatri fed by you. Now look at this.
Okay.
Now come to the existing service rules of 1992, 50 subclause 4.
Yes.
That applies strictly to you. Every officer, of course.
Yes, every officer.
So take all possible steps to ensure and protect the interest of the bank. You have not
But
taken
then,
that.
Lordship, if I am the controlling head and I know that there must not be cash
Now,
disbursals,
how would they know? They
it's
know.
proved. I'm not on reappreciating evidence. I am on what is proved. The inquiry officer, the appellate authority, and the disciplinary authority has held that it is proved against Ashapurna Singh, is it proved against Bhaskar Datta, and it is proved against me. Next, Lordship, next.
Yes.
That the next allegation. The loans were disbursed without verifying and confirming the genuineness of the IDs and without complying with the KYC formalities has been held to be proved against all 3. So that the bank was disbursing cash without following KYC has been held to be proved against all 3. So the controlling authority, the sanctioning authority is as much guilty as me. So they knew. Now next, Your Lordship. 3. 35 mudra loans. These mudra loans are meant to help entrepreneurs start business. Were closed from the proceeds of KCC loans, which are meant for agricultural activities, in contravention to bank's instruction, was held to be proved against me and Ashapurna Singh, who's the controlling. And what did the inquiry officer find, Your Lordship? This is important. That the KCC loans were sanctioned found that the KCC loans were sanctioned not for agricultural activities, but foreclosure of mudra loans, and it was the branch's decision to do so. And I've given you the pages, Your Lordship. So this is the head guy deciding that we will actually have 35 KCC loans to pay off, we have KCC loans to pay off 35 mudra loans. And it was the bank's decision, the branch's decision. Next, Saddam Hussein is the notorious person against whom a lot of allegations, and that is how we've been brought in.
He is
Recovery agent. Now,
he is
look
the
at
recovery
finding.
agent.
Now look at
His
finding of charge 12. That Saddam Hussein, the recovery agent, was allowed to handle loan accounts and application forms against bank instructions is proved against the appellant and the controlling authority. So the controlling authority knew and allowed him to function. Next, Your Lordship. Pre-sanctioned survey, which is my job. I'm the field officer. What is my job, Your Lordship? And I'll show you on page 76. I go to the field and I have to verify that the loan is for agriculturalists. They have land, they need that loan for agriculture, and that's why we are giving it them. That is the pre-sanctioned survey, which I'm supposed to do. Now look at the chart and look at what's proved. The pre-sanctioned survey in respect of the loan was not conducted, while it's partially proved against me and Datta. It's proved against Ashapurna Singh. And Lordship, may I trouble you with 490?
yes.
Which is Ashapurna Singh. So I may be the field ground, but it has been partially proved against me, whereas it has been proved against the controlling authority. And I'm not on reappreciating, I'm on the face of the inquiry officer. Page 490, Your Lordship has. Our pagination is okay, right? Huh? खेली हुई है सर के? क्यों बेटा? Lordship is allegation 3. Lordship has folded.
Yes.
And it's internal page 4. It will be of Ashapurna Sinha. Annexure E.
Yes.
Lordship, allegation 3. And look at the last column, which is the finding of the inquiry officer.
Yeah.
During inquiry, it is proved that though pre-sanctioned survey report was submitted in all cases, but it was not done meaningfully, rather it was done without sincerity. Hence, the IA adjudged the allegation as proved. After going through the reply of the CSO and the findings of I observed that the pre-sanctioned survey was not done meaningfully and thereby defeating the purpose of the pre-sanctioned survey. I hold the allegation 3 as proved. This is proved against the controlling guy and partially proved against me and my immediate senior. So I may be the field officer, but this allegation is proved partially and has been proved against. Next, Your Lordship.
If I were the disciplinary authority, I would have rolled the head of the main man, but then that is
a submission that we
No.
need a scapegoat.
do we enter into that?
No, I am only on findings. I am on findings.
No, you have been able to demonstrate that. They are also equally responsible, but
No,
sentencing part depends because they are at the top head.
Now, Lordship,
Their supervisory role is important. You actually go to the field, you
but
report,
Lordship,
and they have reposed a lot of faith on you. And Saddam. Saddam is not before us, he is just a recovery agent.
Yes, yes.
Bigger responsibility is on them rather than this bank.
Lordship, this allegation 15 is an important allegation. It has been partially proved against me and has been proved against and I'm not reappreciating evidence. I am on what the inquiry officer found. The inquiry officer found that 927 out of 968 cash disbursals the controlling and the sanctioning officer allowed. The inquiry officer found no KCC guidelines were followed by the sanctioning officer and the controlling officer. The inquiry officer found that mudra, that is a charge against me, was sanctioned by the bank. So I was allowed to service mudra loans by KCC loans. The inquiry officer found the notorious, so to speak, Saddam Hussein is known to the sanctioning officer and allowed to handle loan application by the sanctioning officer. Look at your lordship, what is the losses of 2 crores? And these 6 allegations is what led to the loss. If what led to the loss is proved against all 3 of them, and the pre-sanction, which is important, is partially proved against me, but proved against him completely, and pre-sanction is my job, and he knew that I did not do my job, and he still allowed it, that just because I'm now low on the rank, am I supposed to be facing the harshest punishment and they can get off? I'm not, lordship. That is my thing. So therefore, disbursement made in cash without following procedures prescribed, without verification, proved. Loss of 2 crores, proved against all 3. And Saddam Hussein, known and was allowed to deal with, proved. Now, lordship, what was not proved against me? Or should I go back to my note? And lordship, I'm just beginning because there's more I need to show, which it says that the infirmity is lot more than the ordinary.
Take that. We are admitting it. We have heard Ms. Gayatri Goswami, assisted by Mr. R.J. Das, learned advocate for the appellant, and Mr. H. Borgohain for the State Bank, for the respondent State Bank of India. The appellant has questioned the judgment dated so-and-so passed by a learned single judge of this court in WPC number so-and-so, whereby he has not interfered with the decision of the discipline, with the sentence imposed upon with the punishment imposed upon the appellant of dismissal. The records reveal that the appellant was suspended and faced a single overarching charge under Rule 68 2, bracket 2, 68, then bracket 2, and then Roman 2, again in bracket, of the SBI Officers Service Rules 1992, relating to the alleged irregularities in handling loans, particularly Kisan credit cards, Kisan credit card loans, and agricultural unsecured credit account recoveries. This charge was broken down into 16 specific allegations, which the bank treated as standalone proof of misconduct. The allegations centered on negligence, dishonesty, and exposing the bank to a financial loss of approximately 2.5 crores. 205 crore, 205 lakhs.
2.05 crores.
205 lakhs. The contention of the appellant is that the proceedings, that the disciplinary proceedings were unfair to him, driven by external pressures, and that he was made the scapegoat for his being the low man on the totem pole in the entire system. Low man on the totem pole in the entire system. it has been argued that the papers would reveal that the appellant was chosen to be chosen to be made and look responsible for the systemic lapses where two other higher authorities of the bank were also found to be, if not equally, but in a large measure, responsible for such loans having gone bad. Inquiry after it was found in the inquiry that 11 allegations were proved against the appellant. 2 only were partially proved and 3 were not proved. The appellant was saddled with the most severest of the penalties of dismissal from service on 29/11/2019, forfeiting his gratuity and treating his suspension period as not on duty. The appeal preferred, the departmental appeal preferred by the appellant was rejected. The major ground raised in this appeal is of institutional bias in a public sector bank where the appellant as a low functionary was singled out for punishment despite shared responsibilities in loan proceedings. The incidents involved rapid sanctioning of numerous KCC loans, some of which were found to be irregular, leading to recoveries which were ultimately found to be improper. The further contention on behalf of the appellant is that the learned single judge, while evaluating, the learned single judge, not while evaluating, did not consider appropriately the facts of the case regarding the principles of parity and non-discrimination. When the papers clearly revealed identical or similar charges against senior officers, but they were let off with minor punishment, with major punishment, but of only reduction of the scale of pay. The distinction sought to be made by the bank, by the respondent bank, what weighed with the learned single judge is not rational. And in any case, any arbitrary differentiation is unconstitutional. The core argument, therefore, the core argument on behalf of the appellant, therefore, is that the so-called graver allegation against him, according to the learned single judge, is unique remains unrelated to the loss. Leaving no justification for harsher treatment than other co-delinquents. The inquiry findings also have been stated to be, the inquiry findings also are stated to be unreasoned and non-evidence based. The appellant alleges Malafide's predetermination of guilt, submits that there is no proportionality of the penalty imposed upon him vis-a-vis the guilt. This appeal is admitted for hearing. List this case for hearing on, we'll fix it sometimes in June. Your labor has seen this case being admitted. You have broken it down with specific charts. It's whether we can go into it, we'll see, we'll examine it with a different lens. Today we were inclined to dismiss the petition, then we have admitted it. Let's see on some other date.
Right.
So and so. All right.
11 June.
Sure. Yes.
Item 9.
Yes.
My lord, Lordship had heard the matter at some length earlier. My
Fine,
file is
fine.
on the way, my lord.
File is on the way. Your file.
My lord,
हमारा पहले भी
Zunir had suddenly gone for lunch, my lord.
Yeah,
probably.
मेरा problem क्यों हो? मेरा file.
My lord, otherwise,
ठीक है
लिखो, तब तो आज नहीं हो सकता. Because we have a reference. I'll have to go there.
oh, my lord, I understand.
So we adjourn it for some other date.
My lord.
लिखिए. Let this work. Why was it
शायद
dismissed?
ये इसके साथ लेके गया मैं तो
Oh.
घर में गया काम
Get a
देखा
file line.
Okay. यहाँ नहीं मिल रहा है.
वो 1911 का ऑर्डर में हम लिखा हुआ है इसमें
Let this matter come up for consideration on next week में कभी भी.
Next week. 27.
It's in the death reference matter.
भगवान Mr. Ahmed for
I'm appearing for the,
Your name Micus.
In
Who
that
appears for the appellant.
Mr. Ahmed he should
Mr. Ahmed, today we might not be able to take it up.
Sure.
But will not be giving a long date. Today is
Can
Thursday.
it be on this month itself, my lord?
Next Thursday.
Next Tuesday, my lord, can it be?
Next Tuesday or this
Tuesday.
coming Thursday?
Huh?
Thursday
Coming Thursday.
Tuesday, my lord, I have other matter fixed, criminal appeal, my lord, before a division mention.
Anyway, Tuesday.
Tuesday.
Because we have to go to that building. We may not be able to conclude it.
Tuesday 42 meters already
Tuesday, we have already 42 matters. We can't. On 31st of March.
31st March.
31st, I will not be here. My lord, for the
Mhm.
week, I'll be going out, my lord. Then it
Second
will go to ultimately, my lord, after Bihu.
But I don't want to do that.
2nd April.
Then any working day, we will hear you from 3.
Wednesday भी कर सकते हैं इससे भी miscellaneous day
Wednesday?
can do it then
देखो Wednesday को कितना है?
This is 22 meters.
करेंगे, we will do it at 3 p.m.
Yes.
We fix a time at 3 p.m.
25
1.5
March.
hours is good enough for appeal.
I have gone through the entire, my lord, matter.
All right. Let this.
To sustain the death sentence, but conviction, my lord.
Anyway, that day, you don't disclose your
I'm sorry.
arguments today. Let these two matters, let the death sentence reference number 2 along with criminal appeal number 185 be listed for final hearing on
25-3.
Hmm?
25-3, next week.
25-3 at 3 p.m.
May I make one clear, Lordship, that registering of directly to reflect our names in the cause list, Lordship, that is not
His name is
reflected.
not reflected.
The name of the learned counsel for the appellant in criminal appeal number 185 of 2025 must be reflected in the cause.
And also the amicus
Uh,
media.
Must be, the name of the learned advocate and the amicus must be reflected in the cause list.
I am also appointed as amicus in the jail appeal, Lordship. Both-
All right,
both are-
your
both
name,
both are
the
amicus.
name of the learned counsel for the parties, including amicus, must be reflected in the cause list.
Obliged, Lordship.
Item 10 and 11.
Yes,
Item 11, Lordship. It is connected with,
TDS license.
yes, Lord.
I think the government would be making that amendment in the rules. There, I was told on the last occasion, you were not there,
Lordship.
Mr. Nath was here.
Not was it.
He had submitted that they are contemplating of making a change. I think immediately after the elections it shall be. Let these two matters be listed for consideration on after elections,
After
Elections.
after the 23rd of April.
Obliged.
Yes, Mr. Das, you're sitting here for which case?
There are two matters in the supplementary list.
24 and
24, 25, these are high court matters regarding pay parity. Perhaps morning mention was made.
Lordship, here, Lordship, on the last date, we had jointly requested a matter to be listed on the 1st of April, Lordship, to enable us to file the affidavit from Finance Department. Today, Lordship, the matter got listed, perhaps in the order, it was reflected as 19-3, Lordship.
Let these two petitions be listed for consideration on. Then it goes on.
This, Lordship, we'll file the affidavit in the time.
21st of April.
Lordship.
Fine, fine. Highly acknowledged.
दरवाजा अंदर से बंद है इसमें अंदर से बंद
फाइल मिला कि नहीं मिला? Where was it? उनको सुन ले. We still have time. If you've got your file. चलो तो आपकी बात सुन लेते हैं.
Authorised is not there. Prohibitions is there.
छोड़ो. चलो.